This is Lenny the Lawyer Live, and today our topic is frequently asked questions about bankruptcy. But first, before we get to our questions, we got to briefly do some housekeeping. I don't know which forum you're watching this video on, but if you're watching on YouTube, make sure you click the top of the bell icon and hit the subscribe button so you get future videos. And if you stay to the end of this video, as an added bonus, I'll tell you how you can obtain a free consultation where legal advice can be given. This only applies to people in the New York or New Jersey areas, not any other parts of the country. Now, let's get started with the most frequently asked questions about bankruptcy. And remember, this is legal information, not advice. One of the most popular questions I've been asked in the 37 years that I've been practicing bankruptcy law is, my wages are being garnished. Can bankruptcy stop my wage garnishment? The answer is yes, except in very rare instances which are beyond the scope of this video. When you file bankruptcy under Section 362 of the automatic stay, all legal proceedings that are in effect against you must be terminated, and your employer will be notified by me that your wages can no longer be garnished due to the filing of the bankruptcy. In addition to that, the creditor's attorney who's garnishing your wages will be notified as well, and they will have to stop, and they will have to refund the money that's been taken for up to 3 months prior to the bankruptcy. That's right, up to 3 months prior to the filing of the bankruptcy, you can get your wages back that have been garnished. Another question I'm asked frequently is, can bankruptcy stop lawsuits from proceeding against me, or that are already started, or when a judgment has been obtained against me? The answer to that is yes. Like I said, under Section 362 of the Bankruptcy Code, an automatic stay goes into effect. Federal court takes priority over state court. So therefore, any lawsuits, and the Bankruptcy Code specifically provides an automatic stay, and all lawsuits against you have to be terminated. Anything that has been taken from you will frequently be able to get it back as well. And the number one question I'm asked about bankruptcy is, can bankruptcy prevent me from losing my home? And the answer is absolutely. But you've got to be able to make the planned payments to the Chapter 13 standing trustee. And we'll tell you more about that if you schedule a consultation with us. First of all, when you file for bankruptcy in New York and New Jersey, the automatic stay goes into effect. And we will file the bankruptcy and make a motion to have you admitted to the Bankruptcy Court's mortgage modification program. When you're admitted to the Bankruptcy Court's mortgage modification program, you make 3 to 6 trial payments. Your lender must consider mortgage loan modification, and the lender can't play the same games they do in state court. Because in bankruptcy court, everything is submitted electronically through what's known as the DMM portal, so it's timestamped. And if the lender tries to play games or denies getting documents, or that they just don't act right, well, I can take the matter before a bankruptcy court judge and let them decide when it's appropriate. Now, if you're approved for a mortgage loan modification, you will have to make between 3 and 6 trial payments to the mortgage lender. I recommend that you make those payments only by certified check and send them to the lender by certified mail, returned receipt requested. And try to send it at least 7 days before it's due, because even if they receive it sooner, it's not necessarily posted to to your account. And it's when it's posted to your account that matters. Now, if you're approved for a permanent loan modification after you've made successfully and timely 3 to 6 trial payments, if you're approved for a permanent loan modification, you're usually going to get a 40-year mortgage at prevailing interest rates. The interest rates have started to rise, and right now they're as low as they're going to be, and the Federal Reserve has indicated that they're going to be raised 3 to 6 times this year. So it's important that you act fast. Also, by obtaining a mortgage loan modification, your monthly payment should be lower than what you're paying now because it's a 40-year mortgage and your interest rate is going to be less. However, you must make all payments on time. This is not something to play games with. The sooner you act, the sooner you will get the best rate possible. Now, another popular question I'm often asked about bankruptcy is, if I file for bankruptcy, will I have to wait 10 years before I can get credit again? And the answer to that is no. If you file a Chapter 7 bankruptcy, between the time you file and the time you get your discharge, it'll take 4 to 6 months to get your discharge. Once you get your discharge, if you're my client, I will guide you towards reestablishing your credit at no additional charge. That's right, I'll guide you to reestablish your credit at no additional charge. Now, because you can reestablish your credit, you'll be getting a fresh start. Initially, it will be just fully secured credit cards, but then after 1 year of treating your credit properly and making those payments on time, those cards will become unsecured. But a detailed discussion of that is beyond the scope of this video. Now, if you file a Chapter 13 bankruptcy, it'll be easier to get credit, especially once you've completed the bankruptcy itself. Because typically in a Chapter 13 bankruptcy, you file the Chapter 13 bankruptcy either to save your house, protect your car, or anything else that would otherwise be paid in installments that you're currently behind on. Now, you'll be able to establish new credit because you'll be making those payments. And if you have any questions, or if you get any offers for credit while you're in the bankruptcy, then you would discuss that with me, and I will tell you what to do and what not to do. And one of the other questions I'm asked about bankruptcy frequently is, what's the difference between Chapter 7 and Chapter 13 bankruptcy? A Chapter 7 bankruptcy is commonly known as a liquidation, but that doesn't mean it's an actual liquidation. You see, when you file for bankruptcy, whether it's Chapter 7 or Chapter 13, you have to list all your income and expenses and all your assets and liabilities. The value of all your personal property is garage sale value, which means what would a free and willing buyer pay for your item? And if you don't have a house and you're filing Chapter 7, you'll have a WILDCARD exemption to protect those things that otherwise would not be protected. Also, a Chapter 13 bankruptcy is what's called a reorganization or wage earners plan. In that case, you're filing because you have too much equity in your home to file a Chapter 7, or you're going to be seeking a mortgage loan modification, or you're protecting an asset that you would otherwise be making monthly payments on that you've fallen behind. Now, Chapter 7 and Chapter 13 each require what's known as a meeting of the creditors. Frequently, which is also known as a Section 341A hearing. In the old days, creditors used to show up to those 341A meetings. Now it's not very common. The 341A meeting will take approximately 10 minutes start to finish. And until the courts reopen for in-person sessions, it will be by secured video conference or, depending upon the trustee, by telephone conference. And you'll be asked a series of questions. And once the 341A meeting is over, if you're in a Chapter 7, you'll get your discharge in 4 to 6 months. And at a future point, if you're in a Chapter 13, your bankruptcy plan will be confirmed by the court and the trustee. Now, since you stayed to the end of this video, as I promised, if you're in the states of New York or New Jersey, you can call me at 973-798-6131 for your free consultation, either by secured video conference or in person. Only in a personal consultation will I provide legal advice. Nothing in this video that I've told you about so far is legal advice. Now, there are all types of bankruptcy attorneys out there, and you can't believe everything you see on the internet. I'm not going to get into specific, I won't name names and I won't name specific types of ads, but in life, as a general rule, you get what you pay for. I've been licensed for 37 years. I'm not a bargain basement attorney. And when you file for bankruptcy with my firm, it's done right, and it's done right the first time. I have fixed the messes of many a bargain basement attorney because they didn't have a clue how to handle a case. Remember, in New York and New Jersey, and in most states, only attorneys are authorized to practice law. So when you have your house and your whole financial future at stake, you shouldn't trust that to anyone other than an attorney. And now, this is the end of the video. Stay tuned for future videos and tell me in the comments section below, or send me an email or direct message, depending upon which forum you're watching, and let me know what other questions you have and what else you'd like me to make videos on. And we'll be sure to make a new video to accommodate you soon. Thank you for choosing to spend your precious time with me today. I know time, like health, is never replaceable, but I hope this was time well spent for you. Thank you and have a great day.